Let me quickly just get the chat up here so I can see it in case anybody has any questions. Just some housekeeping. I will be sending out another question that I will give you. We're going to say tentatively I'll give you 3 weeks to write it up. This is another question. It'll be another question from last semester's or last year's final. What I want you to do on this one, it's going to be significantly more dense. And those of you who looked at the last problem know that the last problem was really dense, but this one's even crazier. I want you to, instead of, because I do get a couple of you wrote up full essays, don't do that for this one. I am only going to be accepting outlined answers. And then again, we can do the same thing. You send it to me in an email, we'll go over it, set up a time to meet and whatnot. And I'll give you some pointers on how you can approach these problems. With that said, we're just going to touch up on the last portions of landlord-tenant, talking about discrimination in leasing and real property. Most forms of discrimination are technically legal, although they may be unfair or unwarranted. It is legal for a landlord to refuse a transfer or lease because the prospect went to a rival school, for instance. This is just a sort of a housekeeping thing. Is we do want to point out that there is, when a landlord can discriminate against prospective tenants in most circumstances, and that's just because, that's kind of the whole point of having like an application process for a tenant, is you can discriminate based on, the ability for somebody to be able to pay for the property. You can discriminate on, this even extends to, if you are hiring for a job. Like we know that many jobs discriminate based on, how well you did in school or if you have a criminal background or not. The same applies for discrimination in landlord-tenant situations. The general default is that discrimination is permissible unless there is an express legal basis not to. So what this means is just your default position should be, unless there is a literal statute that says that you can't discriminate on a certain basis, you can discriminate on that basis. And again, those of you who have, have experience with looking at the law, that there's already the things that we hate most in this society, just as like public policy stuff. We already know it's illegal to discriminate on those. So when we say that you're allowed to discriminate for these purposes, it's not, for instance, like on race or gender. It's usually for like things like economic ability to actually afford the place that you're buying, which is a protection for the landlord, as opposed to, that's how we'd think of it, is it would be a protection for the landlord. Or it'd be something like, discrimination based on age. Like if you're not of a certain age, you can't, lease or something like that. So it's usually the things that we despise most in terms of what we think of like really bad discrimination have already been made illegal to discriminate on those bases. So that's what this line here is saying is, from the Reconstruction period onwards, usually the impermissible discrimination factors are race, gender, ethnicity, disability, or national origin. In 1968, we had the Fair Housing Act. So the Fair Housing Act is limited to the forms of discrimination that are enumerated, and courts cannot expand and contract these forms as they normally would. So again, you guys have pretty much gotten through your first year of law school. You know that courts do often expand if a piece of law or language within a law is vague. Courts have expanded what those laws may cover. The Fair Housing Act has actually specific provisions that say that courts cannot go beyond the language of this particular statute, and it's geared very specifically for housing. So that's a unique portion of this law, is that Congress, when enacting it, made it very specific that they did not want this to become an overly expansive piece of legislation. The Act also provides for remedies, including damages. So when you guys take remedies, this will mean a little bit more to you, but this Act has like built in, the Fair Housing Act is very hand-holdy with judges. It makes the courts follow a very specific process. So it guides out what courts are supposed to dole out in terms of remedies. The Fair Housing Act does not apply to private clubs. However, the states may reach further than the Fair Housing Act and limit discrimination of such clubs. So this is just to say that if it's like I'm trying to think of a specific situation, but you have like a private housing club, the federal government has, this particular act does not limit the ability for those groups to discriminate on the basis of race, ethnicity, disability, or national origin or gender. But states in like 100% of the, in California, there is much more expansive housing laws. I was going to say in most states, that's also the case, but I'm actually not sure. But states have often taken the Fair Housing Act and then expanded it with their own state laws to make it so that even these private sorts of clubs can't discriminate on the basis of anything laid out above. In 1998, the Fair Housing Act was amended to include disabled individuals and families with children to the protected classes. So that means that the protected classes are now race, gender, ethnicity. I guess it was already included in my initial. Also now families with children. So if you had, if you were a landlord who didn't want to have a family in your property, that's no longer something you can discriminate on the basis of. But you have to find another reason as to why you wouldn't allow somebody to live within your property. So this applies to discrimination in the sale or rental of housing. Again, we're just talking about it. Again, you can't discriminate on the basis of sex, family status, national origin, race, color. Disability is also included in that. There are some exceptions. Single family household or rented by an owner. If the owner maintains and occupies one of the living quarters at their residence, so this would be a boarding situation. So this is if you're a landlord and you own a single family household and you live in that household and you're renting just like one of the rooms, you can discriminate on family status because you can discriminate. You can discriminate on a number of bases for that, but it's most specific to family status because, for instance, you'd say, well, I only have a limited space that I'm living in to rent out, and I can't have a family of 4 living in a single room in my house that I'm living in that's going to disturb my own peace and quiet. That would be a situation where you could say, I'm renting out to one person, or I'm renting out to a couple specifically, or something like that. That would be an instance where there's an exception because the owner lives within the household and you have limited space. Another exception is the exception in section 3604, the language, no ads that specify a preference for a certain race. So this is less of an exception and more of a clarification. It just this is an old one that's never used, and I doubt it'll appear on your exam, but it just basically says that, like, again, it's not really an exception. It just kind of is a clarification because this act didn't extend to the solicitation for tenants by landlords, and so this was a way that sort of it encompassed it a little bit more. Again, I'm not entirely sure why it's under the exception section there. 2 ways for tenants to make a claim under the Housing Act. So this would be somebody who's been discriminated against and they haven't been able to get a piece of property or been able to rent from a certain landlord, which they believe is covered by the Fair Housing Act. So a prima facie case for disparate treatment consists of the following. And again, so they would bring an action to show disparate treatment. So they need to prove for prima facie these 4 factors or 4 elements. They are members of a protected class under the Fair Housing Act. They sought and were qualified to rent the property. The defendant refused to rent to the plaintiff, and the housing was put on the market or was rented by other tenants. Pretty easy, but the big thing is you have to show, first that, you were a member of a protected class, that you sought and were qualified. These first two are relatively easy because it's just, is it true or is it not? This third one's also true. And then again, the last one's also true. And then the burden shifts. Proving disparate treatment claim can be difficult. And the reason that is you can prove all of that pretty easily. And then if you come back and the landlord defendant basically says, well, we didn't bring them on for another reason, that's also very easy to do. So it's very easy it's very easy to prove your prima facie case, but that doesn't mean you succeed because the burden then shifts to the landlord defendant, who then will simply say, we didn't, I didn't bring them on, or I didn't give them the property because of economic reasons, they couldn't pay for it. Or I'm sorry, no, that would have been shown in the prima facie case. It would have been something like, the other tenant, the other prospective tenant made a better offer or something like that. It would be something, very easy to prove why there was a different form of permissible discrimination. It was economically more beneficial for the landlord defendant to pick a different tenant. So that's why this is kind of difficult to prove, because it's easy to prove your prima facie case, but it's also very easy for the landlord defendant to come up with a different reason as to why you weren't allowed to be a tenant. Then there's the second possible claim. So this is disparate impact. These claims challenges practices. Sorry, that's a very weirdly worded sentence. The claims challenge practices that have disproportionately adverse effects on minorities and otherwise unjustified by a legitimate rationale. To succeed on a disparate impact claim, the plaintiff must show the following: that the rule was outwardly neutral, that on its face, the practice or rule does not appear to discriminate against a protected class of individuals. I actually think that's what let me reword that. I think that's what the defendant has to prove. Sorry about that. It was towards the end of the semester when we were writing this, so, cut us some slack. A disparate impact would be something like, there is a rule that on its face isn't discriminatory, but the effect of that rule is discriminatory. And so the defendant shows that first, the rule was outwardly neutral, and then it doesn't discriminate against a protected class. So I'm trying to think of how this would work. It's hard to come up with an example for this, just because these are also incredibly hard to prove, because it's kind of one of those things where on its face, this particular rule would be okay, but it's just the effect of that rule is bad. And so a lot of the times these are very big jury, these end up being cases where it's a trier of fact issue and you have a jury that makes all these decisions. So a lot of courts don't really get deeply involved in these. It's a lot of jury decisions on these because, again, everything's fine on its face, but you end up having a situation where the effect of it, or the fact, of these rules is causing a problem. Again, I'm trying to think of a specific scenario in which this would occur. I'm blanking right now, but again, just keep an eye out for things like the rule is outwardly neutral on its face, and then it is discriminatory in its follow-up. The difference between these two is that impact refers to the consequences of the actions, whereas treatment refers to the mindset of the individuals. So in an impact situation, you might actually have, there may never actually be a want to discriminate, and it just so happens to be that the effect is that there's a discrimination. Whereas in a disparate treatment situation, there is like an actual provable mindset that there is, you know, the landlord wants to discriminate. So just keep that in mind. You can look at the problem here at the bottom. This is the, excuse me, this is the problem on page 400. But we're going to go ahead and finish up there today. You know, I mentioned that we were going to be, you know, not going to take a ton of time. So I'm just going to kind of leave this up for a second. You're more than free to copy it down. You can stay after for questions if you have any. I will be sending out the problem for you guys later today, and I will send out the day that I need a response back for that problem. But if there are no other questions, you guys have a great day, and I will see you later.